All right, good afternoon, everybody. Good afternoon, everybody, and welcome. It's great to welcome everybody to our 2024 Ulysses S. and Marguerite S. lecture. It's great to see such an amazing turnout. Here again, the law school is like putting on events no one wants to come to. Let me tell you a little bit about the Schwartz lecture. The Schwartz lecture was established in 1974 to bring distinguished lawyers with experience from the academy, from practice, from public service, to the law school to share their perspective and their experiences with our students and members of our law school community. And Judge Ulysses Schwartz was a longtime supporter of the law school and had a legal career that began as a special assistant city prosecutor here in Chicago way back in 1910. And he eventually served as on the Illinois Supreme Court, retiring in 1973. After his death the following year, a number of friends and family came together and wanted to honor Judge Schwartz by establishing this lecture series in his honor. And then in addition, his son John obtained his JD at this law school, and he too became a judge. He became a federal bankruptcy judge here in the Northern District of Illinois, and eventually serving as chief judge of the bankruptcy court for a decade. Now, over the course of its history, the Schwartz lecture has brought many distinguished speakers from across the world to come and speak and share their varying perspectives here at the law school. And it's a pleasure and honor to continue that tradition today by welcoming today's Schwartz lecturer, Elizabeth Prelogar, Solicitor General of the United States. General Prelogar received her undergraduate degree from Emory, where she majored in English and Russian. She then obtained her law degree from Harvard, where she was a member of the Law Review and competed as a finalist in the moot court competition. She then held a number of really impressive roles. She was a clerk for then Judge Merrick Garland of the U.S. District Court of Appeals for the District of Columbia. She then held not one, but two Supreme Court clerkships, first with Justice Ruth Bader Ginsburg and then with Justice Elena Kagan. And following these clerkships, she then combined a period of private practice at firms such as Hogan Lovells and the law firm Cooley, with multiple roles of public service, particularly in the Solicitor General's office, in particular serving as assistant to the Solicitor General, principal deputy Solicitor General, and acting Solicitor General. And in these roles, she's argued multiple cases in appellate courts, including the U.S. Supreme Court. In 2021, President Biden nominated her to become the Solicitor General. Now, General Prelogar will be in conversation with our faculty colleague, John Rappaport. I think many of us all know John Rappaport is a path-breaking scholar of criminal law and criminal justice. He has an undergraduate degree in mathematics from Stanford and a law degree from Harvard. He clerked for Judge Stephen Reinhardt, the U.S. Court of Appeals for the Ninth Circuit, and then at a later point in his career for then Judge Paul Watford, also then of that court. He also clerked for Justice Ruth Bader Ginsburg at the U.S. Supreme Court. He practiced law both at a firm and as a public defender before joining our faculty, first as a Bigelow Fellow, and of course, now as a professor. I am very grateful to him for leading our conversation with the Solicitor General, and we'll have a little bit of time later on after their conversations for questions. So thank you all for being here. And again, please join me in welcoming Solicitor General Elizabeth Prelogar.
So Elizabeth, welcome again one last time, and thank you for being here. I want to begin by asking you a few questions about your time before you were the Solicitor General. And I want to start actually back at the very beginning. You were born and grew up in Idaho, right?
Yes, I'm a proud Idahoan.
And I think this makes you something of a rarity in elite legal circles. And so the question for you is, what impact, if any, do you think that your background growing up in Idaho has had either on the way you approach learning the law or the way you think about and practice it today?
Sure, and let me just say at the outset, thank you for that warm introduction and welcome, and I am so thrilled to be here with all of you today. I really appreciate everyone turning out on a cold day. I know that getting the lunch doesn't hurt, so I appreciate that, and I'm really glad that we'll have the chance to have this conversation. So you went back to the very beginning. I was born and raised in Idaho. I love my home state. I still think of it as home. I actually had moved home during the pandemic, and so I was living in Idaho when the president asked me to come back and be the acting Solicitor General at that point in time. And I still have a lot of family in Idaho and love going home there. And I guess the biggest way it had an impact on my career and my approach to the law is a little less about the place and more about the people. And in particular, my dad was a lawyer. He was a very different type of lawyer than I am. He and my mom moved to Idaho, and he basically hung out a shingle and practiced a little bit of everything, some probate law, some family law, a little bit of criminal law. And I feel like through his experience and through his practice, it was an early introduction to me about the way that the law shapes people's lives and can very much have a direct impact on their day-to-day experience. And actually, one of my very earliest memories was watching my dad in action. My mom, he had a big criminal trial, and he was representing the defendant. And my mom took me to court, me and my sister. And I was pretty young at the time. My overarching memory is that I was so bored. But I still can remember what the courtroom looked like, and I was interested in the role that all of the different participants, the judge and the witness and my dad were playing. And I think it opened my eyes to what he did and in a very direct way. And it all comes full circle because last year, for the first time, my younger son came to watch me do a Supreme Court argument. And he was 9 at the time. So I had him keep a journal to entertain him. I thought he might get a little bored. It was a very complex immigration case. And he shared the journal entry with me afterwards. And the very first lines were, "We're driving there. I see the Capitol. I'm bored." So I totally deserved that.
Did you always know you wanted to be a lawyer? When, was this like this moment, watching your dad and you thought, I think I want to do that? Or
No, not at all, actually. Even when I went to law school, at the time I had been very invested in journalism, print journalism. I was on my college newspaper. It was my big passion. I had interned at a bunch of newspapers and thought, I'll go to law school, get this professional degree, and then I can write about the law and try to make that my specialty in journalism. So even when I went to law school originally, I thought I would not practice.
Do you think the background in journalism affects the way you think about legal writing?
Oh, absolutely. It's obviously legal writing is its own art form, but I think that I learned a lot in my experience in journalism that directly translates, including things like getting to the heart of the matter, trying to make it digestible, breaking down complex ideas. All of that, I think, works in legal writing as well.
So after law school, as Dean Miles said, you had 3 amazing clerkship experiences. First with then Judge Merrick Garland, who's now your boss again, right, in the Department of Justice. Then Justice Ruth Bader Ginsburg, where you had terrific co-clerks. And finally with Justice Elena Kagan, who had just finished her stint as the country's first female Solicitor General. There are a lot of students in the room who are thinking about clerkships. Some of them have clerkships lined up. Some of them are just hearing about clerkships for the first time. Can you tell us a little bit about your experiences and how those experiences as a law clerk informed your subsequent work?
Yes, and I'll just say at the outset, for those of you who are thinking about clerkships, I think it was an incredible experience at the start of my legal career to have the chance to work with these 3 amazing jurists, all very different in their own ways, but to have that kind of front row seat to seeing how they approached the task of judging, how they thought about the law, how they reacted to different advocacy styles. There's just no replacement for that kind of experience and for forming the type of lifelong relationship with a mentor that I think very naturally arises out of a clerkship. So I'm a big fan, and I'll just put out there that it's something that you should think about and maybe throw your hat in the ring for. And I just lucked out. I mean, I clerked for amazing judges and justices. I feel like I learned so much from each of the clerkships, and they were all a little bit different. With Judge Garland at that time on the DC Circuit, one of the things that really struck me about that clerkship, and it's my first job straight out of law school, is that I could spend weeks preparing for an upcoming argument. I would read all of the parties' briefs, and I was writing my bench memo for the judge. He called it a getting started memo. And I would pour myself into reading every case and thinking hard about the issue. And I could have spent dozens of hours on it. And then I would turn in the packet to him, and he would spend all of about an hour looking at the materials and then come to my office without fail and ask me, the toughest question at the very center of the case. He just had this amazing capacity to distill the essence of a case, to recognize exactly where that pressure point is and where all the action's going to be. And it was really incredible to see him do that and to kind of learn from that. And so I still today, as I practice, always am thinking about where is the fault line here? What is the central thing I need to be thinking about with the case? Then I went on and got to clerk for Justice Ginsburg, who's amazing. And one of the things, the memories that really sticks with me about this clerkship, and I can't remember how I mentioned it to my co-clerks at the time, my wonderful co-clerks, but it was...
Thank you.
One night, the justice and I were there late. She was a night owl. She did not come in early in the morning, but she was often there very late at night. And we were working on a draft opinion together, and so I had stayed late as well. But somehow we got off on this tangent, and she started telling me some war stories from the time that she was litigating for the ACLU Women's Rights Project, helping to enshrine principles of equality into our constitutional law. And she was walking through some of the cases she had argued. And these are well-known, famous cases. I was familiar with them. And I was familiar with them because of the important constitutional principles they stand for. But in my conversation with the justice, she was really focused on telling me the stories of the people in these cases. She remembered all of their names and how many kids they had and the injustice they had faced that brought them to her as a client in need of help from the legal system. And it was just this, these cases she had argued decades earlier, but it was very clear to her that the cases stood for much more than these grand constitutional principles. They really stood for real people being affected and needing the aid and protection of the Constitution and the legal system in order to correct that injustice. And I just feel like she was always that way as a justice too, focused on the facts of the case, very cognizant of the way that the court's decisions affect real people's lives. And so that's something too that I always try to keep in mind as I'm litigating cases now. My client currently is the United States, which is a unique type of client. But obviously the cases and the issues that I work on can have profound effects on people's lives and on the course of our country. And so I feel like that's something I took from her. And then Justice Kagan, this was an incredible clerkship to follow up after my clerkship with Justice Ginsburg. And one of the defining memories for that one, Justice Kagan at that time, I think she probably still does this, she would prep for oral argument by having all of her clerks come in and talk about the cases for hours in the lead up. And so, there was a principal clerk who had been assigned to write the bench memo, but all of the clerks would have a discussion about the case. And it would be wide ranging. She would just pepper us with questions and solicit viewpoints. And my memory is, there was never a moment when Justice Kagan was more disappointed than when we all agreed on the case. She hated that. Sometimes she would sit there, I think, in frustration and she would want the disagreement because she would really want to hear the strongest arguments on both sides. And she's not one who would ever shy away from confronting and thinking about the hardest argument on the other side of where her instinct might lie with respect to the correct resolution of that legal issue. And so there again, I feel like I carry that with me and think hard about really grappling with and taking seriously the fact that there are often not bad arguments on the other side. You've got to, especially with Supreme Court litigation, usually it's circuit splits and judges around the country have divided on an issue. So it's not like any case is a slam dunk. And you really have to think hard and engage with the arguments that run against you too, to figure out how best to thread a needle in thinking through your arguments in a case.
Do you think they shape the way you write?
Yes, absolutely. I think that both with respect to the brief writing and with respect to oral advocacy, you have got to be willing to confront and take on the strong arguments on the other side. All the time, justices will ask hypotheticals at argument, and I think some advocates, maybe more inexperienced advocates, will often say, that's not this case. And it, almost always triggers a response or a reaction from the justice who asked the question of, I know that's not this case, but the point is that I have to think about the broader range of cases and the legal principle, and especially where the limits might be of your theory. And so I feel like understanding the ramifications of the positions you're taking and what the arguments might therefore be on the other side are critical to preparation.
Interesting. So after you had started working at the Solicitor General's office, but before you were the Solicitor General of the United States, you were actually detailed for a while to Robert Mueller's special counsel investigation into Russian interference in the 2016 election, which, as an outsider to that process, seems like it must have been a really intense experience. Are you able to share with us anything about that experience? I'm curious what your role was, given your background as an appellate advocate. And I'm also curious whether you got to use your Russian language skills at all.
So I've often joked that this was the most interesting job I've ever had that I can't say anything about. That's not quite true. So I can tell you a little bit about my role. I was on a legal issues team. So the Mueller investigation, focused on obviously several distinct episodes, and there were investigative teams and prosecutorial teams that were focused on aspects of that. But there was also this separate legal issues team that worked across the range of the issues that were coming up in the investigation and the potential prosecutions. And it was a variety of questions, big and small, little things like, would venue for this particular type of charge lie in this particular place? And then big questions about things like, can a president obstruct justice through the use of his official powers? And so there was just a wide range of legal issues that Mueller had to confront. And I was part of a team that was dedicated to trying to work with all of the other prosecutors. But it was a very different role than I was used to, being in an appellate office. I was coming directly at that time from being a career attorney in the SG's office. And I remember very early on feeling this huge sense of imposter syndrome. Mueller had hired these incredibly experienced prosecutors from around the country, those who had really deep experience in international money laundering and public corruption, and just a deep well of experience. And I remember early on, we were all sitting at this conference table having lunch together, and they started going around the table, and everyone was sharing their favorite story of a time they had flipped a witness. And it's kind of going around, and I'm just sitting there feeling this tremendous sense of like, who does not belong at this table? I can't flip my kids and get them to cooperate with me. So it was just this really interesting experience to be surrounded by those who had practiced a very different type of law than I had, and to get my bearing and figure out what is my role here. It was not Russian language. It turns out that my Russian language skills are very rusty, and the FBI has linguists who actually do this for a living. So that was not what I ended up contributing to. Not why they recruited me. But it was a great experience. For me, it really confirmed that my true calling is appellate law and Supreme Court advocacy. But I felt like I had the chance, to contribute through public service to an important investigation and to help with those legal issues that came up.
That's interesting. Thank you. Thank you for sharing what you could. So now, of course, you are the Solicitor General of the United States. You represent the United States before the U.S. Supreme Court. So my first question for you about this job is, how do you decide what position the United States will take in a particular case, including in the many, many cases in which the United States appears as an amicus curiae? Who's involved in the process, who signs off on it, and so on? I imagine it could be quite complicated because there's all sorts of different subject matters and different agencies involved. How does that all work, and how do you come to decide what the position of the United States is and what you're going to say in the brief in support of that position?
So it really is an extensive process. We are participants in the overwhelming majority of the cases the court hears each term. And in a lot of those, we're a party. And so, we've either been sued, or it's affirmative litigation on behalf of the government, or maybe it's a federal criminal prosecution. So we have staked out our position in the lower courts, and that's kind of the easier set. Although obviously even there, we take a hard look at the issues when they go up to the Supreme Court. It's not frequent, but sometimes we'll confess error if we don't think we can actually defend the lower court's judgment below. But those cases, we've usually already had a lot of thought process that goes into our positions. The harder category are the amicus cases that you mentioned. And anytime the court grants review in a case, we will take a serious and deep look at it to see if it affects the interests of the United States. And most of the cases do, because although we are not a party, they affect our interests if they're touching on other legal issues that might affect our litigation or government programs more broadly. But as you noted, it's not as though in each of those cases, it's always immediately apparent where our interests lie. And this gets at what I was mentioning earlier about the United States being a pretty unique client. It is, the federal government has a wide range of interests, and they don't always line up in the same direction or even on the same side of the V. And the example I always use, just to try to make this more concrete, is to think of a Title VII employment discrimination case. The United States has significant interests in that. We have interests in civil rights enforcement through our Civil Rights Division, in robust protections for workers and a proper interpretation of anti-discrimination principles. We have interests through the EEOC, which has a lot of subject matter expertise in this particular area. But then we also are the nation's largest employer. And despite our best efforts, we sometimes, as the United States, are sued under Title VII, and our civil division represents the government as the defendant in those kinds of suits. And so we also have an interest in ensuring that the rights of employers are protected and coming at the issue from that defense side interest. And so if you think about a typical Title VII case, I'll be getting recommendations from civil rights and EEOC and the civil division and anyone else in the government who's affected. And they might have very different takes on what the interest of the United States is and what position we should take to best advance that interest. So the way we deal with that and it is to, first of all, run a very intense internal process of making sure that we get all of the relevant considerations on the table. So we solicit far and wide, any agency or department or division that has subject matter expertise or has programs that could be affected by the issue in a case, we will ask them for a recommendation. And we do this in writing because we think it really brings a measure of discipline to have these interests articulated, both focus on the legal arguments and what this component or agency thinks is the right answer legally, but also to write out why they think pressing that legal argument would advance the overall interests of the United States. So I'll get recommendations from far and wide all throughout the government.
Do they always respond? It's a serious question. I mean,
Yeah.
so do you send out memos to the different agencies?
Yes. So basically, through the relevant litigating component in the Department of Justice, the solicitation occurs through them. So I'm not personally saying, hey, DOD, please tell me what you think. But it's a well-known SG deliberative process. And so it's clear that the point of this process is to inform ultimately my decision making. Mm-hmm. And yes, it would be very rare for them to not participate if they actually have an interest. Now, sometimes the solicitation gets blasted out far and wide, and an agency doesn't really have much of a stake, and they won't submit a formal recommendation. But we feel like this is the best way to try to make sure that nothing is falling through the cracks, and we really have I have all of the relevant information before I'm making a decision. Mm-hmm. So these recommendations come in. The case is assigned to a line attorney in my office. I served in that role for a number of years. And also a deputy who will have subject matter expertise in the particular area. The assistants are all generalists. The deputies have dockets that are a little more specialized, although everyone does a little bit of everything, I would say. And they will write me recommendations. And so by the time this decision point comes to me, I often have 5, 6, 7 different recommendation memos. Sometimes it's an easy call. Everyone agrees we should obviously do a certain thing. But in a substantial number of cases, they're divided recommendations. And so that means, sometimes more process, having a meeting. I'll get all the stakeholders in a room and I'll have a bunch of questions and we'll just talk it out. Sometimes, I think hard about whether there are ways to narrow our arguments or navigate through a case to protect interests that might fall on both sides of the legal question. So if you ever see an OSG brief with this, oblique footnote that seems to be talking about something that isn't directly teed up in the case, it's probably because we're trying to protect some interest or something that could stand to be affected, but we don't want the court to resolve it, for example. And at the end of the day, I have to make a call, and it's not possible to please everyone. I have to say no a lot. But I feel like the fact that we have this very rigorous process and provide all of this internal procedural due process means that at least the component of the government that's going to be disappointed by the decision feels like they were heard. And that's always my goal. I want to make sure that no one ever thinks that I am making a decision without having actually taken into account and considered the views on the other side.
So it doesn't sound like there's much of a top-down component. I mean, you could imagine a world in which you call the White House, right? And the White House says, we're the executive, we represent the United States, this is our position, right?
There are really well-worn processes, and I didn't invent them. This is how OSG has functioned within the government, for what feels like time immemorial. Mm-hmm. Certainly sometimes there are issues that affect the interests of the president, where the White House will be a client in certain respects, mm-hmm. and then they'll provide input, but it's always through this kind of recommendation process.
So they get sort of no more say than other clients? Yeah,
I mean, it's really, I think that both the department and the executive office of the president recognize it works best that way. Mm-hmm. There's just it's not the norm for the White House to be directive about the positions we're taking. And certainly I think it's entirely within the realm of the reasonable to make sure that all relevant perspectives are heard. But there just is, OSG has a very well-defined process for how decision-making happens.
What about private parties? So if there's litigation either between two private parties or a private party and a state or something like this, and each side wants you to weigh in on their behalf, do the private parties submit recommendations, or how does that work? What's the process when there's private parties involved?
So yes, we also provide the chance for the parties in the case to make recommendations. Usually what happens is if we're thinking about amicus participation, we will invite both sides to come in and talk to us. And they have the chance if they want to submit written views as well. And it's their opportunity really to try to speak to the legal issues in the case and why they think they're right about the correct outcome of the case, but also to pitch us on the government's interests. And a lot of times they will try to identify things we've said in prior briefs or points that they think are relevant in the litigation that they think supports an amicus brief on their side from the federal government. Or sometimes they can correctly ascertain that we're not likely to support them, and they'll make a pitch that we should sit it out and don't have enough of an interest to participate in any event.
And you have actual in-person meetings for these?
Yes. So the attorneys in my office, the deputy and the assistant to the SG, will run those meetings. I don't personally attend those.
Interesting. So one thing that's really striking about the Solicitor General's docket is the enormous variety of case types, right? It could be an Eighth Amendment case one day, a class certification issue the next day, a Voting Rights Act case the following day. It's an incredible amount of material to master. And so I'm curious whether you have, within that huge amount of material, whether you have sort of favorite subjects, pet subjects, and how you decide which cases you're going to argue personally. Is it solely based on the perceived importance of the case? Or does subject matter play a role as well? Like if you really hate, bankruptcy, but it's the most important bankruptcy case ever, will you argue it because it's the most important case, or do you sort of bow out and defer to other subject matter experts?
So I actually feel like this is one of the best parts of my job, and I'm so lucky to be a generalist because you're absolutely right. Our specialty in the SG's office is Supreme Court litigation, and that means that our docket runs the gamut of all of the types of issues that the court itself considers. And I love this because all the time I will, pick up a case that the court has granted, and it's some arcane question of how to interpret a provision in ERISA or something like that. And I'll know nothing about it and think, this seems a little dry, but then I start reading the brief and figuring out the arguments on both sides and realizing what the case is really about. And I'm just a total law nerd. I get really into it, and I find it fascinating to explore new areas of the law and have the chance to learn about them. And argument is no different. I just argued in December a tax case for the first time, and it was a challenge because the court expects attorneys from our office to kind of know everything there is to know about the federal government's operations in a particular area. And so if I'm going to stand up there at the podium and argue a tax case, I need to be ready to answer whatever questions they might have about the tax code. I don't know if you guys have read the tax code, but it turns out that can be a tall order.
We've tried to do our taxes, so that's good enough.
Yes. So you have the general idea of what I'm up against. But I got so interested in this case. It was fascinating, a really important and interesting constitutional question. And at one point, the tax division lawyers were like, you seem really into tax. They were surprised. But I was, because it was this opportunity to learn about a new area of the law and to really dive in to all of the precedent and constitutional history and the arguments that would bear on the proper resolution of that case. So I relish the chance to argue in new areas. In terms of having a favorite area, it's really hard to pick, in part because there are so many different subject matters and areas that have a tremendous impact on our lives. I've done a fair amount in kind of the voting rights space, and that work has been particularly meaningful. So if I had to pick a category of cases, maybe it would be that. But it's really impossible to narrow it down. And in terms of choosing which cases to argue, by longstanding tradition, the SG generally argues once per argument sitting. So that means while the court is in session from October to April, it's usually once a month in the relevant sitting. And the calculus is to try to argue the case that is most important to the United States. Sometimes that's also, and frequently, that's also the case that's probably most important overall. But there have been months where I argued a case because it was incredibly important for federal government interests of the United States, even though it perhaps wasn't on the radar for others as being quite as high profile based on the kinds of issues that the court takes and resolves.
So if there are two absolute blockbuster cases in the same month, you'll just do one of them? And
Usually, yes.
deputy
So yes, we have the deputies then tend to argue as well quite important cases. And in a situation where there are multiple important cases in 1 month, we had that in this December where I argued the tax case. There was also a very important bankruptcy case and a very important administrative law case, and those were handled by deputies in my office. There was an argument session last term where I argued 2 in 1 sitting. It was the independent state legislature case, and I felt that that was critically important for democracy and very important for me to do personally. But then we also had a case called United States versus Texas. This was one of those I mentioned where it can be really important for the United States, even if it's not on the radar, and that involved, fundamental questions about state standing and remedies that I thought were of such sweeping consequence for the federal government that it was worth taking on 2 in 1 sitting. But I do not recommend it. I had moments where, those dreams you have where you've missed an exam or something where I was confused that I would mix up the 2 cases. It was a very intense period.
So let's talk a little bit more about oral argument. How do you prepare for an oral argument? Do you have any particular pre-argument rituals, and do you have any great, oral argument war stories?
Yeah, so I think the number one most important thing to do to try to ensure that you have a good and productive argument is to think hard about and anticipate to the extent possible the questions. So I devote a lot of my oral argument prep time to just working through questions and then most importantly, answers. I do that, in conjunction with a team of attorneys. I'm really lucky in part because I'm often arguing so frequently and in so many different areas. I'm very lucky that I get to draw on the subject matter expertise across the federal government. And so in a case like this tax case, I'm constantly peppering the attorneys in my office who are working on it and the tax division and the IRS with questions to make sure that I fully understand all of the background material that's going to be relevant. But then the thing that I think pays the most dividends in terms of trying to make sure that you are ready for argument is to actually work through the briefs and issue spot, essentially, figure out what are the likely questions. And they're usually obvious, right? You know what the pressure points in a case are likely to be, what the justices will likely be concerned about. And so it's not just identifying the questions, but then really spending the time to try to work through answers. And I have found that any number of times I will think in advance, here's the question, and I know the answer in my mind. But when I actually spend the time trying to work through it, I realize that the thing I'm contemplating saying is going to be too complex. There won't be enough time to get it out. Or there are really 3 points to make, and I need to figure out what is the most important in case I only get to say one thing. And then where do I go next? And what would be my tertiary point? So it's a lot of time spent on that. We have a tradition in the SG's office of doing moot courts that are very intense. The aim is to basically have a much harder moot court than a real argument. And one of the things that is so special about the office is that the mooters are other attorneys in the office. They're always people who are new to the case. So we have a panel of 3 line attorneys who will come in, and they really invest in reading the background materials and trying to think through what questions the court will have so that they can put you through your paces and give you a chance to really have a realistic moot. And what I love is that they do this for all the cases, big or small. It's not, I think, surprising to think that for the kind of typical case the SG will argue, people will put in the time and resources to be prepared. But even for the issues that seem less high profile, they really invest that time to make sure that all of our colleagues are prepared for their cases. So that's an important part of the process. And then yes, rituals and traditions are very important. I have many. I always follow the same routine the night before argument. So I don't work too late. I know some people who the night before argument will stay at the office till midnight. And I kind of figure if you don't have it locked in by 7 p.m., it's probably not going to get better. So I always leave at a reasonable hour, and I go home and I have family dinner. I have 2 boys who are currently 10 and 12. And we always eat the exact same meal.
Really?
And then
which is?
It's chicken, rice, salad, and biscuits with honey butter.
Very balanced.
Very balanced, very filling, exactly. And then at the dinner table, I try out my oral argument introductions on my kids. And they rate me on a scale of 1 to 10. But I'm very lucky because unlike the University of Chicago Law School, there's grade inflation in my family. And so that helps me. The first time I did this, my boys were a couple years younger even. And the case was an immigration case, a statutory interpretation question, and it turned on a provision of the INA. And we had a pretty simple argument that the word in the statute was may, but the states were interpreting it as a shall. So my argument intro focused on that. And I finished my intro, and my older son said, "Mom, I give you a 10 out of 10. You said the statute says may, and that sounded so professional to me. Like, I think they're going to look at it, and it will say may." It did, so he was right. Just like, great job. And then my little one said, "Wow," he never wants to be outdone by his older brother. So he said, "Wow, I give you an 11 out of 10. He said, "But I didn't understand any of that." And I said, "Well, thank you, I'm honored, but how did I get an 11 out of 10 for an incomprehensible introduction?" And he said, "Because we're a family and we support each other." Aww. So, felt like even an SG can't argue with that, right? He's right.
That's very sweet. What about the morning of?
Yes, the morning of, also traditions. I wake up very early because I think it's important to get up and be thinking about your case, and I talk out loud to myself and I warm up. I eat breakfast, always the same thing, bananas. I'm a big fan of bananas for breakfast on argument day.
Just bananas?
Sometimes cashews as well. I had to add in the cashews because arguments are going so long now. And I worry that otherwise, we're not going to break for lunch at a reasonable hour. So bring food, both of them. And then, it's in our office. We all head to court together from the office. And so I head in and get dressed for court. I always wear the same suit. I bought this suit for moot court and law school. And I have worn the same suit for every oral argument. I have dry cleaned it in between, don't worry. And I put on
They don't give you a suit when you're the Solicitor General?
No, you must procure your own suit. And I always wear a string of pearls that my grandmother gave me. She's no longer with us, but I do that to honor her. And then in terms of war stories, actually, because you asked me about war stories, right? Yeah. I have a bunch of those. I realize time is limited. So the one that springs most immediately to mind is the first argument I did as SG. This was a case that also called United States versus Texas. I talked about a different one of those earlier. I've argued multiple cases called United States versus Texas. But this was a case where Texas had passed a law banning abortion after 6 weeks. And this was before Dobbs. The law was clearly unconstitutional. But the state had adopted this very unorthodox enforcement mechanism where anyone, anywhere could sue to enforce the law rather than having state officials enforce it. And the whole impetus behind it, the design of the law, was to try to prevent judicial review and deny a forum to providers so that they could not get a review of their claims that this was unconstitutional before they provided care. And so this was an unusual case because this went up to the court on its emergency docket. The United States had gotten an injunction. It was our affirmative litigation. And then that got suspended. And so we sought relief from the Supreme Court. And instead of ruling on the emergency docket, it actually granted cert before judgment and set the case for argument just 10 days later while ordering full merits briefing in the meantime. And when this happened, my nomination as SG was still pending. So I had to step away from the office while my nomination was pending, but it seemed like a vote on my nomination was imminent. And so with very little time to go, I threw myself into oral argument prep just to be ready, just in case. In fact, on the Thursday before the Monday argument, the Senate did vote on my nomination. And I couldn't watch it because I was in a moot court for the argument in case I got confirmed in time. So one of my deputies came into our moot courtroom and gave me a thumbs up after the vote had concluded, which is how I found out I'd been confirmed as SG. And without missing a beat, one of my colleagues began his next question by addressing me as General Prelogar, which is very nice. But this is a Thursday, the argument's on Monday, and so there was very little time to prep. But the other wild card was that Sunday, the night before the argument, was Halloween. And Halloween it turns out it's a very important holiday in our family. My kids had not trick-or-treated for 2 years because of COVID, and they were so excited to get back out there. And they made very clear to me that it was a command performance that mom had to be there. So I spent the night before this first, critically important argument out on the streets of Capitol Hill with one Rubik's Cube and, one doctor roaming around. And we passed one of our neighbors, and he said, hey, what's going on with you? I was like, I just got confirmed as SG, got a big argument tomorrow. And he said, wow, I guess women really can have it all. Which is not how I was feeling in that moment, I can assure you. So it was a really intense oral argument experience.
Wow. Yeah, that is intense. Just to hear the story gives me tremors. Okay, so let me ask you a question that's been on my mind for a long time. It's no secret that you represent a Democratic administration in front of a court that's composed primarily of Republican appointees and that is regarded as pretty conservative by historical standards. And my question is, how, if at all, does this change the way you go about your job? Do you go into each case actually thinking that you could win? Or do you sometimes go in just trying to lose well? If you do the latter, are those goals in tension with each other, sort of simultaneously trying to win and trying to make sure you lose well? And is it difficult for you psychologically? Does it test your faith in the judicial system?
So, I got asked a version of this question recently at another law school. Do you really think you can win most cases? And I began by saying, maybe you'll think I'm crazy, but I do go into most cases seeing a way to win, seeing a path. And the whole room burst into laughter, which suggested to me they did think I was crazy. But I'm sticking with it. I'm standing by it. Look, I'm a realist too. I recognize that there are particular types of cases where there are going to be enormous headwinds. And sometimes, that's because the justices have written and expressed views on a particular issue before, or because their jurisprudence suggests that they will have particular feelings about a case or its outcome. And there are certainly cases where I know it's going to be much harder. But I would say that the number of cases where it seems like the advocacy isn't going to matter at all, or there's no potential way to try to persuade and convince justices who might be on the fence that we've really got something to our arguments. The category of cases where there's just no chance of that, it is really small. I think that even in situations where it seems pretty unlikely that we're going to be able to get the bottom, the ultimate bottom line result that we want in a given case, there is frequently a lot of room to try to shape how the court thinks about the case and therefore how the court might write an opinion in the case. And this gets to your losing well part of the question, I think. It really matters. The way the court writes its opinions, that matters. And I don't think that there's any tension between going in with a frontline argument, really trying to persuade, trying to figure out the kinds of arguments you can advance that are going to get you to 5, while also simultaneously having a plan B and working hard to make the court aware of, kind of the broader ramifications of different ways to think about resolving a case. And so I am frequently trying to keep both of those goals in mind, but I do go in usually trying to win and thinking maybe there's a shot that I could get there. I'm not always right, sadly, but certainly I try. On the is it hard psychologically, it's certainly the losses are hard. I take those hard. And it's hard as an advocate, as the person who was up there presenting the views and not having them carry the day. It's hard as a human who cares about the issues and who recognizes that many of the cases that I'm litigating have profound effects on people throughout our nation. But I guess I always, console myself with the idea that I am really lucky to get the chance to serve in this role and do what I can to advance the interests that I think are stand for the principles that support the interests of the United States, and to have the opportunity to try to make that case. And I had a mentor, a former SG actually, who said to me at one point early on in my tenure, he said, all you can do is make the right arguments for the right reasons to the best of your ability. And that is no small thing. And I think about that a lot because it really is a privilege to be able to devote whatever skills or talents I have as a lawyer to trying to advance what I believe to be the public good and the right constitutional vision for our nation.
Is there a particular case that you've argued that you're proudest of, either because you did sort of win against odds or because you lost really well?
You know, the case that immediately springs to mind is actually one I argued a long time ago, before I was SG, when I was a career attorney in the office, an assistant to the Solicitor General. And so it's not as high profile a case. You may have never heard of it. It's called United States versus Bryant. This was a case that raised the question of the constitutionality of a federal criminal statute. I think it was 18 U.S.C. 117. And the statute made it a crime to commit recidivist acts of domestic violence. And among the types of predicate convictions that could qualify were, state convictions, federal convictions, but also tribal court convictions. And one of the impetuses for the law, one of the things that Congress was looking at, was the fact that there was a real epidemic of domestic violence on reservations and tribal lands, and that it wasn't getting addressed. And so Congress wanted to create a federal crime to try to hold those who commit these recidivist acts accountable. But it got challenged because there isn't the same right to counsel in tribal court as there is under the Sixth Amendment in state and federal court. And so the argument was it's unconstitutional to rely on tribal court convictions. And that argument, which had succeeded in the lower courts, would have really gutted the statute and one of its central core applications. So we took that up to the Supreme Court. The United States has a general practice of defending the constitutionality of acts of Congress. And here we thought there were, very strong arguments to make in defense. But as part of my preparation for that argument, I traveled to Montana and visited the affected tribe in that case, the tribe that had handed down the convictions that had led to the eventual federal prosecution of the defendant. And it was this really eye-opening experience to get to talk to tribal leaders, to learn about their criminal justice system, and kind of along the lines of what I was saying about RBG earlier, to just see the real-world impact of what this statute did, what it was intended to accomplish, what it would mean for the tribes. And so I just felt this real connection to the on-the-ground ramifications of the arguments I was making. And I delivered the arguments in court. This was a pretty early on argument for me, maybe my third or fourth argument ever. And we ended up prevailing, and Justice Ginsburg wrote the opinion in our favor. And it was just really gratifying after investing that time and energy on an issue I really cared about and having met personally tribal leaders who were affected by this to have the chance to get that result.
Thanks. So I recently read a profile about you in the Harvard Law Bulletin from your alma mater. And in it, a mutual friend of ours actually called you a lawyer's lawyer to the bone. And I'm curious whether you agree with that characterization, and if so, what it means to you. What is a lawyer's lawyer?
So I guess I think of a lawyer's lawyer as someone who delights in the law, in thinking about legal puzzles and trying to solve them, in trying to find connections between different doctrines, in thinking creatively about how to write a brief or craft an argument or persuade, in unpacking kind of the principles under the law in order to best advance the argument in the case. Someone who really enjoys that as an intellectual exercise, as almost an art form. Now I feel like I'm waxing poetic about the law and the lawyer's lawyer, but I guess if that definition is correct, maybe it's not. I guess I do think of myself that way. I mean, I love the law. I feel like it's just an honor to get to have the chance to take these skills, and you are getting them here in law school, take these skills and channel them in ways that matter and make a difference, and that are interesting and intellectually exhilarating to boot. I mean, that is really neat. And I feel like I have been so lucky to land in this position and this role where that is what I do day in and day out. I mean, we are filing in just about every Supreme Court case. These are big, important, complex issues, as I mentioned before, often with reasonable arguments on both sides, and untangling that and, kind of really drilling deep into those cases and understanding the law and how to try to marshal the arguments to advance a particular position. That's wonderful. I love doing that.
You sound like a lawyer's lawyer.
Good. All right, good.
Confirmed, I think.
Thank you.
Yeah. So in just a few minutes, I'm going to open things up for questions. So students, please start formulating your questions now. Do keep in mind that the Solicitor General will not be able to comment about specific pending cases or issues that are likely to come before the court. But my last question to you before we kick it over to the students is, what are the attributes of the best appellate advocates that you've worked with? And I ask this with an eye toward whether you have any advice for students who are interested in appellate litigation, how one can sort of get started as an appellate litigator, get a foot in the door. Is this something that can even be done at big law? Questions like this.
Yeah, so these are great questions. I feel like the attributes that are most important, obviously oral and written advocacy, super important. It's the prime thing you're doing, but I feel like some of the best appellate lawyers I've seen are also really good listeners. Partly it's important to do that at oral argument. You really need to listen to the question the justices are asking you so that you can figure out what's concerning them and take your best shot at trying to persuade them, trying to get to the heart of their concern and answer it conclusively. I think also, though, being a good listener with respect to others, not having too much pride or ego about the particular way you're thinking about the case, being open and receptive to being challenged on it, and to considering, whether there are ways to improve your advocacy or make changes that will ultimately sharpen the issues for presentation. I think that that's a really important skill. In terms of what students who are interested in appellate advocacy can do, absolutely you can get that door opened. I think you can do it from big law, although sometimes it can be harder to get those first opportunities in big law. So I'll put in a plug for government service. That's a great way to get early experience, particularly at a more junior stage in your career. When I first came to the SG's office, I'd clerked for several years and been in a firm for several years. I was maybe the equivalent of a sixth-year associate at a firm, and suddenly I'm arguing multiple cases in the Supreme Court each and every term. What an incredible opportunity to get that kind of experience and to really be able to take ownership over your cases. So if you are at all drawn to public service, I think it's a wonderful way, of course, to contribute in that way, but also to gain relevant skills and experience even at an early stage. And that includes state, public service, and federal. There are a lot of different ways to try to look for opportunities there. In terms of any other concrete advice, I guess, two things really occur to me. One is to be very open and receptive to learning from others. When I look back on the course of my career, I've had the chance to work with many amazing lawyers, and I still do. I feel like I'm continuing to learn on the job every day just by virtue of getting this chance to work in the SG's office with so many incredible people and to see day in and day out how they're crafting a brief, how they're delivering their arguments. But going to places to work where you feel like you have people you can learn from, and then just being really open and receptive to taking that on, I think that you will be able to increase your skills and also find it quite rewarding to develop those relationships. And then the other thing I would say is I really think you have to make yourself uncomfortable, particularly if you're thinking about appellate advocacy. It involves a lot of public speaking, standing up in court and delivering an argument. It's not like it's a low intensity experience. There can be nerves associated with that. And I feel like the things that often are most rewarding in life rarely come easily. They require putting yourself out there, getting outside your comfort zone, and kind of seizing opportunities. I had my big experience that really hits home for me for this was when I was in law school. As was mentioned, I did the moot court competition and made it all the way to the final round where I was an oralist. And Justice Scalia was presiding on the panel. It was a distinguished panel, and Scalia was presiding. And I was so far outside my comfort zone. Everyone in the law school attends this moot court competition. And there I am, 3L, fall semester, standing up, delivering an oral argument in front of this legendary jurist who was known for being particularly, asking sharp and incisive questions at argument. And sure enough, I got up there, and very early on in my argument, I used the word comparator. It was a Title VII issue, and I was talking about, someone who was similarly situated but treated differently. But Justice Scalia immediately cut me off, and he said, "Comparator? I've never heard of that one. Is that even a word?" And the whole courtroom burst into laughter, and I'm like sweating bullets at the lectern thinking, did I get the word wrong? Did I botch the English language? Just for the record, I've at times looked this up, and comparator's been used in like 10,000 federal court cases, including 12 or more majorities, and not that anyone's counting. But, it was this experience, having that experience and having him put me through my paces like that, it was uncomfortable, but it was good for me. And also doing the moot court experience made me really realize this is what I want to do. I want to try and be an appellate lawyer. I find this exhilarating. I find this terrifying, but also exhilarating. And I can honestly say that there has not been an argument that has been more intense or harder than that very first moot court experience. You could say there's no comparator. So
Well done, well done. Okay, so we have time for a few student questions, if anyone has questions for us. Yeah, right here in the front.
Yeah, so I'm sorry if this is like a very basic structural question, but Professor Rappaport asked this, I just wanted to follow up. You said when you were talking about, thank you so much for being here. You said that like the president wouldn't give an order about how the SG's office should do the case. It's more norm-based, non-directive than that. What if they did? Like particularly if we got a president who didn't care about norms as much, or the attorney general.
Yeah, so it's interesting. Obviously, the SG reports to the Attorney General and to the President. And so there is a chain of command overall within the federal government and the executive branch. By long-standing norm and tradition, there is not that kind of direction from the top down. And what I've heard former SGs say, particularly in their confirmation hearings, when they're asked, would you, if you were directed to advance an argument that you did not think was reasonable or you could not stand behind, what would you do? And the answer that I think has been given, Don Verrilli said this, Noel Francisco said this, was I would resign rather than following an order like that. So I think that whatever situations might come up, it would be really important for an SG to be able to think hard about what he or she is willing to do and kind of the importance of those norms and traditions within the office.
Yes, right here.
So the Solicitor General is sometimes referred to as the 10th Justice, and your office has outsized influence both in terms of what cases the court does take, as well as cases that maybe the court does not take. And I'd be really curious to hear a little bit about your strategy when you think about avoiding making bad law, or where you see inroads to potentially making good law, and how you kind of weigh the pros and cons of those decisions.
Yeah, so that's a great question. I should say at the outset, I'm going to borrow a line from Justice Kagan, who in her confirmation hearing to become SG, as John mentioned, she was the first female SG. She said, this 10th Justice thing has been said, but I think the justices probably think of the SG less as the 10th Justice and more as the 37th law clerk. And it's a pretty good line. It sometimes feels that way. But it's true that we really do have a special relationship with the court. Obviously, we are the quintessential repeat player. We participate in, I think about 90% of the court's cases. We also are frequently participating at the cert stage, either through this process called a CVSG, where the court calls for the views of the Solicitor General and asks us to weigh in and make a recommendation about whether it should take the case when we're not a party, or because we are writing briefs in opposition in response to petitions where we won below and don't want the court to take the case. So we are, there in front of the court a lot. And as a result, our integrity really matters. And so we are straight shooters with the court. You asked about thinking about the risk of making bad law or maybe trying to anticipate how the court will react to an issue. We certainly are not neutral players. We're advocates and we're representing a client. But I think that more so than the ordinary litigant, we are really taking account of the fact that we need to turn square corners with the court. And so if we are writing a brief in opposition and we really don't want the court to take the case, but there's a circuit split, we're not going to say there's no circuit split. Sometimes you'll read briefs from the private sector and they'll say, oh, the circuit split is illusory, or they'll find little things to latch on to distinguish the cases. And it's within the realm of advocacy, but we really want the court to know that we are trying to be fair in how we're describing precedent, that we're not cutting corners or taking shortcuts in order to try to achieve short-term results that we like in particular cases, and it's all to advance the greater good of making sure we maintain our integrity with the court. So those are the kinds of factors I keep in mind. And as part of this process I mentioned earlier of deciding our position in the case and whether to participate, a lot of that is thinking about the consequences of making bad law. It's not just at the Supreme Court level. The SG also has a role in deciding whether to take appeals in lower courts. And a huge part of that is thinking through not just what are our legal arguments, do we think we're right, but are we likely to win in this venue? Or is there a good chance we're going to take a bad district court case and turn it into a really bad circuit case where it has more sweeping implications? So those are the kinds of factors we'll keep in mind. And that's, I think, very properly part of the calculus. But it's always with an eye towards trying to navigate through what overall is best going to advance the interests of the United States.
Yes.
Have you experienced both the pre and post-COVID format of oral argument? Is there one that you prefer? Do you kind of like the more old school, just chaos, or the more new school, everyone takes their turn?
So, I love the new oral argument format, and it's a little bit of both worlds, right? Because in the days before COVID, the court would have strict 30-minute per side arguments, and all of the justices, was hurly-burly trying to get their questions in. And as a result, as an advocate, you very rarely had a chance to really complete your thought or answer to a question because there's limited time, it's not going to be extended, and the justices all want to have a chance to put their question on the table. And so I felt like it was sometimes frustrating because you would spend all of this time preparing. There'd be, 3 things you wanted to say, and you could barely get one thing even put on the table for the justices to consider. But the new format, which combines this first 30 minutes of argument with a kind of bonus round of seriatim questioning, I think has actually made both portions of the argument far less chaotic and more productive, hopefully for the justices, but certainly for the advocate. Because the justices know they're going to have a chance to ask in the seriatim round, I feel like they also let you complete your thought in the initial 30 minutes. They're not cutting off your answer in order to squeeze in their question because they know there's going to be a real opportunity. And then, of course, the seriatim question, that round, I think is really useful because it gives an opportunity for each justice one by one to lay out their concerns. And sometimes those concerns are not going to be you are not going to be able to address them, but you'll have the shot. You'll be able to hear how each justice is thinking about the case, or at least the thing that they think is most central and important that they want to put it out there and hear you react to it. So I love it. The downside, of course, is the length of oral argument. For those who are sometimes listening during the live stream, arguments now can routinely go on for hours. It's the rare case where I'm not up there for a full hour now. Because of the nature of the cases I'm arguing, those often tend to go particularly long. I had an experience last term where I was arguing in the affirmative action cases. There were 2 in one day. Court starts at 10, so the cases were scheduled to run from 10 to noon. My husband had come to watch me argue, and I ran into him when court concluded, and he was rushing because he was late to pick up our kids from school, which ends at 3:15. And it had occurred to neither of us that this argument could possibly go until 3 p.m. in the afternoon. So I think that one those 2 cases set a new record. But that is the only drawback from the format, I think. But to my mind, it's worth it because you really then get to use the argument as a chance to hear what the justices think and to give your responses.
I think we have time for one more question right here.
One thing I want to pull on a little more that you mentioned a minute ago was, I know the Solicitor General famously has this special relationship with the Supreme Court, but also, you take appeals sometimes at the circuit level and the level of the Courts of Appeal. And I'm wondering to what extent you have a relationship with the different circuit courts and how you manage the relationship. For instance, when there's a circuit that's seems to be more opposed to the priorities of the administration.
Yeah, so we definitely, I feel like, kind of take into account the need in deciding whether to take up issues on appeal, whether we have credible arguments to make in the circuit court, right? It certainly is different than the cert practice because the court, a lot of times you can appeal as of right, and so there's not a relevant question of whether the case satisfies discretionary standards for further review, which is something we think about all the time in the Supreme Court. We're not going to file a cert petition on any issue we think we unjustly lost below if it doesn't actually satisfy the criteria for cert. There's no circuit split or something like that. In the lower courts, we don't have that additional calculus, but we do think about the nature of the arguments we'd be presenting and how the court is likely to react to them. And I think that that's an important part of the process as well. It's not at all a secret that it requires SG authorization to take an appeal in the first place. And the reason to centralize decision-making is to make sure that we're taking consistent positions throughout the country and that we are making those decisions about whether to seek further review and invest the further time and resources with an eye towards the broader interests of the United States and not just focused, single-mindedly on a particular prosecution or a particular litigation. And I think the circuit courts know that. And so they know that if there is, if the United States is an appellant in the case, that required SG authorization, and that, that hopefully, I don't know to what extent empirically this is true, but hopefully they know that that means we ran a process. We thought hard about it. We didn't just file the notice of appeal and go forward with the appeal without any deliberation given to that.
Well, great. Well, thank you very much. I want to thank Professor Rappaport. I want to thank General Prelogar. This has been illuminating and delightful, and thank you so much for joining us. I have one sort of housekeeping matter, which is that whenever we have an important person with a great responsibility come, their schedule is incredibly tight. So I just want to make sure that we can get the Solicitor General to her next location as we conclude. But most of all, I want to express my thanks and gratitude for the insights you've shared. And thank you so much for joining us here at the University of Chicago.